Okay. Thank you very much for joining us, everyone. This is John Howard Society Week, and I'm Catherine Latimer. And we are very pleased to be bringing you a series of sessions on bail and bail reform issues. And today we're very pleased to be joined by Mary Campbell, who has extensive experience in the law reform and parliamentary processes, and is going to talk a little bit about the process associated with Bill C-14, which is the bill that the government has put into play, which is amending provisions related to pretrial detention and release. And we're also pleased to have Shakir Rahim with us, who is with the Canadian Civil Liberties Association, who has done extensive analysis of actually the contents of Bill C-14, and he's going to share some of his insights and findings around that bill with us. So really looking forward to that. I'm also supposed to indicate that this this session is being recorded and will be posted on our YouTube panel afterwards. Okay, so Mary, maybe you could share a little bit with us about this interesting policy development and legislative reform process that we're in.
Sure. Thanks very much, Catherine, and thanks to John Howard Society for a great week so far. Ria, you could throw up the first slide. I have very non-substantive 2 slides, but I will send out my talking points, which have much more of the detail in them. I thought they'd be too distracting right now. So, yeah, I've done a lot of parliamentary legislative reform. So I wanted to just briefly say this is sort of what, if you like, a normal process of legislative reform would look like. It's very linear. A very important first stage, which is the pre-legislative process, where you have a proposal that could come from any one of a million sources. The public servants develop it, hopefully undertake consultation. There's a memorandum to cabinet, and that's followed by the drafting of a bill before you ever get near Parliament. Now, that process could take years. For example, the Corrections and Conditional Release Act, because it was a wholesale revision of an entire act. It could, and has on occasion, take a matter of days. I recall once being called to a meeting reluctantly on a Monday night on Parliament Hill, and by Friday the bill had gone to final print. That's not a great way to do legislation, in my view. It was a little short on the consultation, needless to say. But I think that pre-legislative process is so important. So that's what a normal process would look like. Very linear, very straightforward, very easy to follow. Next slide, Ria, would be the C-14 process. Not linear, if I may say. It just, as I'll be covering, we have a study, we have other bills, we have witnesses where there's no bill, we have witnesses where there is a bill, we have an SCC decision in the middle of it all. One of the many infamous quotes, we need to do something. Well, yes, indeed, we need to do something. So that kind of sums up the process in contrast to what the normal process should be. And Ria, you can take that slide off and we'll just enjoy my lovely look. Dial back to last September. Try to remember where we were in mid-September. September 15th, Parliament came back from its summer break. And on the 18th of September, they didn't waste any time. The Justice Committee met and they agreed to 2 items of business. They were going to do 2 studies. One was on the tools to combat child luring and exploitation, and a second study on strengthening guidelines for repeat offenders, especially violent ones. On both of those studies, they were going to have at least 4 meetings and issue a report with recommendations to the House of Commons. So that was the Thursday. Next Tuesday, they met again and said, "Oh, forget it. No, not what we said last Thursday. Yeah, we're still going to do a study on combating child luring under the same conditions, but now we're going to do a new study, not that other one on repeat offenders. We're going to do a new study of at least 8 meetings on issues relating to bail, sentencing, and the handling of repeat violent offenders. Furthermore, we're going to hear from provincial representatives, and park that one in your memory, law enforcement, police associations, victims, and other witnesses deemed appropriate by the committee. So some of you will be pleased to know that you were deemed appropriate. They were going to have the two ministers, Justice and Public Safety, 10 for no less than an hour each. Forget about the Public Safety Minister, he never did show up. And they were going to prepare a comprehensive report on this study with findings and recommendations and request a government response. It's a big plan. That was on the Tuesday, so right away on the Thursday, they heard from 3 groups on this study, and they happened to all 3 were police groups. And we'll have more to say about that again. A couple of days went by on break. October 2nd, we heard from the Canadian Association of Black Lawyers. We heard from CAFES and CBA, as well as CCLA. I hope you all know the acronyms, I'm sure you do. John Howard Society, and not to forget the police, the St. Thomas, Ontario Police Force also appeared. That was on the 2nd. On the 7th of October, we heard from Nicole Myers at Queen's, Michael Spratt, and the CLA, Boris Bejtensky. Then there was a break week. Okay, so study's well underway. Then there's a break week, and FPT ministers happened to meet at the end of that week, and I'm guessing they had a discussion about bail. When they came back, the committee sat on October 20th and heard from 4 more former witnesses, Professor Sundberg from Mount Royal, the Assembly of First Nations, the Winnipeg Mayor, and the Federation of Canadian Municipalities. So all of those sessions have been held on the subject matter of bail, but without a bill in front of them. So it was really, the presenters were talking about, you know, here's what we think is wrong, here's what we think is needed, but they had no clue what was in the legislation. However, on the 23rd of October, C-14 was tabled, and there was one more session that had victims, another police group, and well, 2 more police groups actually. So at least those witnesses had the advantage of actually having the bill in front of them to kind of focus their comments. So up until that point, there had been 5 meetings, 18 witnesses. The largest group was police, lawyers, academics, 1 Indigenous group, a couple of victims, NGOs, and these municipal reps. There were also briefs from some individuals and groups. So over in the House at that point, end of October, they launched into, of course, second reading debate of C-14. They had 4 sessions actually in the House. If you're feeling masochistic at any point, by all means, you know, have a look at them. So that's over in the House. But meanwhile, committee is still working away. And on November 6th, while second reading was going on in the House, the Justice Committee met and decided that C9 should again be a priority. And that's the hate crimes bill that has been a wee bit controversial. So they had a panel with 4 witnesses who gave statements. But then MP Brock, Larry Brock, interrupted with a motion about a Supreme Court of Canada decision that had just come down. Seneville is the name of it. And the court had struck down some mandatory minimums for child porn. MP Brock was extremely upset about this. The witnesses that had started on C9 were dismissed. There's no time for questioning them. And the committee talked about doing a report to the House of Commons on this dreadful Supreme Court decision. They didn't come to a conclusion. They suspended the meeting. They came back on November 18th to continue their study. Now you might say, well, which one now? So they're back on their study of bail and violent offenders. And Mr. Brock said, let's spend the first 2 hours on bail and sentencing and the 3rd hour on that awful Supreme Court decision. MP Fortin from the bloc objected, but he lost. And I might say parenthetically, he would be a good contact for people to talk to. I was quite impressed with MP Fortin. So first 2 hours on the bill, or the study, excuse me. First panel, Mayor of Brampton, more police, Toronto police. And then on the second panel, they had 4 victims. So far, they're still chatting away about this. And then they were supposed to turn to the SCC decision, but instead they suspended. I don't know why. So back over in the House, remember them, they're doing second reading, and they finished that on November 18th. They passed the bill and referred it to committee. Meanwhile, back at committee, on November 20th, 2 days later, they do a report on the Seneville decision and send that off. A few days later, they're supposed to be at clause by clause of C9. They did not do it, or was not completed in any event. I know some of you, I've sent these quotes to you. Really, I'm out of adjectives for the Justice Committee. My favorite quotes, my point of order is that her point of order is not a point of order. Okay, my point of order is that we don't have to say anything at all. So they went on and on like that, really getting nowhere. It's my notes say lengthy, rancorous debate. So that was the end of November. December 9th, they come back, the committee. House of Commons has moved on to other business, obviously. December 9th, they come back, and the Conservatives try to move to a study of C-14 at that point. My notes here say, unbelievable, weirdest committee session ever. Now, I had 13 years officially of attending committees, so to label it as the weirdest committee session ever gives you some idea. It was so political, it was so partisan, speeches were being made. They were just, some people were obfuscating, they were blocking, whatever. So that was December 9th, and I think they all said, well, okay, let's all take a break for the holidays. So they suspended. They come back in January. Okay, remember they're supposed to be doing this study, and also they've had the bill referred to them. So they come back January 26th. They're all excited at the new year. They agree that they're going to suspend the clause by clause of C9. Forget it. They can't deal with that. And now they're going to have 3 meetings on C-14, one of which will be the Justice Minister. And the third meeting will include clause by clause. So this is a lot of people who don't know the background were a little upset when they heard that second reading was only going to be 3 meetings, one of which was the minister, that this was really insufficient time to study this really important bill. But you do have to bear in mind they had all these previous hearings, even if they didn't know what was in the bill. By the way, on their study that they had launched back in September, no report on that study was ever tabled. That just kind of disappeared into the ether. So next we were then into this 3-meeting committee stage. There were quite a few written briefs that were handed in, 17 by my count. And the 3 meetings started at the end of January. So January 28th, the minister and his officials did appear. Public safety never appeared. February 2nd, they had 2 panels with 6 non-governmental witnesses. Now, the odd thing about this was a couple of them were people who had previously appeared when they were doing their study. And so I had to say, well, if you've only got, kind of 1.5 meetings, why are you having repeat witnesses when there are so many others that should be appearing? And I don't have an answer to that, other than the committee clearly liked these repeat witnesses. Professor Sundberg from Mount Royal got a lot of attention. I don't know him. I've never met him. In his second appearance, because he was a CBSA officer at the border for 15 years before, he then focused on aligning immigration policy with bail policy. I got a little nervous during that testimony, I must say. And again, as I say, the RCMP bargaining unit, the National Police Federation, appeared again. I don't know why. Then there was another hearing on February 4th. And again, very much, again, another police group, repeat, the Toronto Police, and civic groups and mayors, retail groups, who talked a lot about, the dangers on the street and how merchants are suffering and that sort of thing. So that's the February 4th hearing. This was the third hearing that they were doing on C-14, and that was it. They then commenced, after hearing these witnesses, a lengthy side trip into C9 and C16. They sat until 1 in the morning, 1:06 to be precise. There was a great deal of speech making. They were, as I say, this was supposed to be second reading of bail, but they were back and forth on the hate crimes and C-16, which get ready for that one coming to committee. And they did finally do clause by clause, and they made 20 amendments, which were mostly technical amendments, although mercifully they did add these provisions for mandatory reporting by the Justice Minister on bail. But what you note here, because this was obviously the end of hearing of witnesses, remember back in September when I said that they listed who they wanted to hear from, and they said provincial representatives? No, yet not happening. They did not hear from a single provincial prison witness, provincial AG's office. Now, when you're talking about bail and what we've heard, the excellent presentations this week, I kind of think it'd be pretty important to hear from your remand officials at the provincial level, but no, they were never heard. A week later, they did move then to report stage into the House of Commons. There were 9 motions to amend the bill further that were tabled. They did not get anywhere, mostly rejected on technical grounds. So then report stage passed on division, and third reading similarly passed on division. So for C-14 in total, there were 9 meetings. There were 38 witnesses. However, by my count, 16 of those witnesses spoke when there was no bill in front of them. So it was a more general discussion. And 22 of the witnesses at least had the bill in front of them. Who were the most represented among the witnesses? Well, you won't be too surprised, police and the municipal or retail organizations. Each one of those groups had 9 appearances, nine witnesses. That's, you want to hear from the police. That's a lot of police. By my count, there were 5 lawyers, 6 victims, 4 NGOs, 4 academics, 1 Indigenous group, which again, we're talking bail and remand and sentencing and high-risk offenders. I would have thought maybe more than 1 Indigenous group might have been called. And at the very bottom of the list, as I have emphasized, 0 provincial corrections representatives were called to speak or offered themselves to speak. There were quite a few written briefs submitted. I'm getting a little nervous, and maybe I'm being unfair, but I'm getting a little nervous about how many of those briefs are being read by the committee. They have a couple of Library of Parliament research staff on the committee who are absolutely excellent. You can read their summary of the bill. And it may be that, of course, they read those written briefs in some detail. I'm getting a little nervous about the committee's attention. So overall, the process that went on really was so partisan, so political. The witnesses all did their best, although many of them mentioned, of course, the lack of data. Other witnesses often spoke of, well, the crime rate is this and that's that. And of course, they never give a source for any of these figures. The committee never sort of challenges them on the source. But there were quite a few representations that obviously, look, we're throwing darts in the dark here without any data on bail. And the process in its totality, as I say, I've never seen a committee hearing that has been so politicized, scattered, back and forth. You just want to yell, focus, people, focus. And that didn't happen. I would point out that all members of the committee are lawyers, except for one. Now, some of you will say, well, there's your problem. I tend to have a different perspective on it. I like to think that lawyers know better. The one who wasn't was a former journalist or media person. Yeah, it just was not a great process. Now I've talked my allotment. It's over to Shakir to talk about the substantive issues in the bill that kind of weathered the storm of this chaotic parliamentary process. Thank you.
Thanks so much, Mary. Shakir?
Great. Thank you as well, Mary. I think that's a solid foundation to understand, just how imperfect this process has been and this bill is. And I want to thank also John Howard Society of Canada and Catherine for putting on this wonderful week. I think it's doubly important in this time of misinformation that we are hearing from experts in a deliberate fashion about these issues. So in my remarks today, I'm going to use the CCLA's forthcoming brief to the Senate Committee on Legal and Constitutional Affairs on Bill C-14 as a little bit of a guide for some of the points that I make. And we're going to share that brief as well to everybody on this call once the day is done. And there are obviously a lot of concerns with this bill, so I won't be hitting all of the points, and I'll be focusing as well on bail, but I think you'll get a flavor for some of the most pressing substantive problems with it. So let me start briefly by talking about the state of the bail system itself. Now, you've already heard on some panels about this, so I won't go on at length, but I think it is worth just re-emphasizing where pretrial detention is in Canada and the notion of bail as a contributing factor to the crime rate. And so you'll see here in our brief, we highlight this. So we highlight first the percentage of provincial and territorial prison populations that are in pretrial detention. And all of this information is from Statistics Canada. And you'll see that the rise has been, meteoric, to say the least. We're looking in the late 1990s, at around 35%. Now, as of last count, we're looking at 75% of provincial and territorial jails being comprised of people in pretrial detention. So certainly, I think that strongly undercuts the notion that we are in some kind of particularly lenient or extraordinarily lenient system of bail in Canada. At the same time, you'll see below that chart, two charts that pertain to the overall crime index and the violent crime index. And the reason I share those is you can see that, these indexes have fluctuated in different ways at different times, while the pretrial detention figure has continued to go up. And so, when people say, well, we can kind of draw this causal link between leniency in pretrial detention and the rate of crime, the fact that we see these indexes, changing while the pretrial detention rate just continues to go up, I think really suggests that there isn't much to the notion that we can draw a concrete conclusion about, the rate of bail denial and public safety. If anything, we're at a record, it seems, in terms of pretrial detention. So ostensibly, all these figures should be, on the floor. So I think it's just important to visually see that to challenge some of the narrative that we hear. At the same time, and you heard this referred to by Mary and some of the other panels as well, I'm sure, is, we are really in a data desert. And it's a point that 3 ministers of justice now on bail have readily conceded. You'll see in our brief, we have a quote from Minister Fraser, who is the current Minister of Justice and obviously sponsor of this bill. And he said, it's not as though there is an effective national data set that will demonstrate conclusively that certain changes will or will not have a desired impact. So that's the territory we're in, where the government itself is saying, we just don't know what this will do, but it's really important that we do it. So what does a C-14 in fact do? Well, one of its most significant legislative provisions concerns the expansion of what are called reverse onus provisions. And these provisions essentially flip what the usual burden is in a pretrial release decision on its head. So in the usual course, it is the state that has to bear the burden of saying why someone should be detained. And that makes intuitive sense, right? You have not been convicted of anything at this juncture in the criminal process. The state wishes to take away your liberty. It's up to them to say either you should not be released, or here are the types of conditions that must be imposed. A reverse onus changes this. It's now you who bears the burden of saying why you should be released, why you should be able to maintain your liberty. And the Supreme Court of Canada, when examining these provisions, has held that that is on its face equivalent to a denial of bail under Section 11E. So it is in and of itself, the introduction of that type of analysis equivalent to a denial of bail. And then, of course, there are narrow circumstances in which the court has ruled that can nonetheless be justified. So what this bill does is it introduces 3 classes of new or expanded reverse onus provisions. The first are offense-specific reverse onuses. So for certain criminal offenses, if you are charged with them, you will now always face a reverse onus situation. And those offenses are a motor vehicle theft involving violence, a motor vehicle theft for a criminal organization, breaking and entering, certain human trafficking offenses, and so forth. So there's these offense-specific categories. There's also new stage-specific reverse onuses. So the most significant of which, I think, is that now, after someone has been convicted of an offense, but before they've had their sentencing, they will now be in a reverse onus situation if they would like to remain on pretrial release. And then finally, there are more record-specific reverse onuses. So for example, the length of time in which you will face a reverse onus provision if you have a prior conviction for violence with a weapon is now going to be 10 years. So these are the kind of 3 buckets of new reverse onus provisions this bill introduces, and this is a fairly significant expansion. In addition, the bill will quite significantly, in our view, change how the law of bail applies to reverse onus offenses. And there are two principles of the law of bail that are particularly impacted. One is the principle of restraint, and the other is the latter principle. So the principle of restraint is a principle that basically outlines that, primary consideration should be to the release of the accused at the earliest reasonable opportunity and on the least onerous conditions that are appropriate in the circumstances. And there's a bit more as well, as you'll see on the page. And it has been both codified in the criminal code. It was codified in Bill C-75 in 2019. And the Supreme Court has recognized that it has a constitutional dimension as well. So it actually is also rooted in the Charter of Rights and Freedoms. And again, if we think about where we're at in the stage of the criminal trial process, restraint makes sense, right? Nothing has been proven against you. The existence of statutory grounds for detention are there, but really, at this stage of the proceeding, the interest is in preserving your liberty as much as possible because there has been nothing proven against you. And that's why you have this idea of release at the earliest reasonable opportunity. So Bill C-14 removes that first part of the principle of restraint, that primary consideration of release at the earliest reasonable opportunity for all reverse onus provisions. And so certainly that changes how a court approaches that question of, what's the analytical lens that I use to see how I should be applying the law of bail and conducting a pretrial release analysis. Second, the latter principle itself is disapplied in reverse onus situations. What the latter principle refers to is really something that began right at the time of the Bail Reform Act in 1972, which is the idea that, when it comes to determining the type of pretrial release, there's sort of a ladder of types of releases that you climb. So you might start with an undertaking without any conditions. That can go up to a surety release. That is to say, where either you have to show that you have one or more people who can sort of be your supervisor, if you will, in the community. There can obviously be pledges that have to be made, promises to pay. That's usually below a surety release in the first instance. And then, of course, we get all the way up to things like requiring a cash deposit before you're able to be released. And there's been some debate in the jurisprudence about whether the latter principle applies in reverse onus situations. When the principle does apply, essentially the Crown has to go through this process of rejecting each rung on the ladder. It can't just say we're going to start at this point in the ladder, like a surety release is what's necessary here. And so this legislation basically says, look, we're going to say that it does not apply. So we see now that reverse onus provisions are going to have an even greater impact than they already do, right? So they already create this shifting of the burden. Now they're also going to result in the disapplication of some fairly important principles of the law of bail. At committee, there was also an amendment added to C-14 that introduced new surety restrictions. And the restriction is now that any person with a criminal record for an indictable offense in the past 10 years can no longer serve as surety. And that's a pretty significant change, and one that has the potential to really negatively impact certain communities that are already overrepresented in the criminal justice system and overpoliced. And that includes Indigenous communities, Black communities, and other vulnerable groups. So aside from kind of the overall considerations I've outlined so far, what are some of the concerns with these, new substantive proposals that we see? Well, you've heard already, and I've mentioned the fact that there's no evidentiary foundation that has been offered for these new reverse onus provisions, right? So there's been no analysis put forward that says, with respect to these offenses, we are noticing these types of issues in the operation of the bail system, and that is what justifies these interventions. Instead, we've seen a lot of rhetoric about, well, certain offenses are perceived to be occurring more or perceived to be committed while people are on pretrial release, but little evidence offered in support of those types of assertions. The other point as well, and I think this has sometimes gotten lost, at least at the level of the media coverage of this bill, is that these new offense-specific reverse onuses are not limited in any way to so-called repeat and violent offenders. Now, even if they were, that doesn't mean it passes any kind of constitutional or public policy muster. But certainly, if you look at how this bill is being sold to the Canadian public, it is that there's a type of offender who is completely non-compliant with pretrial release orders to whom this bill is directed and to whom these provisions are limited. In reality, of course, the new offense-specific ROs are applicable to anybody. There is no statutory criteria related to prior offending or prior non-compliance with the release condition. And so the effect of this is that there are a lot of people who are going to be alleged first-time offenders and who are nonviolent with respect to the allegations. Nothing's been proven at this point, of course, who are going to be captured by these new reverse onus provisions. And so, you'll see that we highlight two of these groups in our brief that we think are going to be, real unintended consequences of this bill. The first is the new reverse onus for organized crime-related auto theft. And the challenge with how this has been phrased is it would apply to anyone who acts at the direction of or in association with a criminal organization. So membership in a criminal organization, prior history of involvement, all of that kind of thing is not a necessary component. And what that means is that there are a lot of populations, whether it be young people, people who might be in abusive or asymmetric power type of relationships with members of organized crime, etc., who may in fact act at the direction of a member of a criminal organization, but really, are either very young persons who, have very clear off-ramps that are available to them from future criminal involvement, or, really are not the type of people who are, hardened members of organized crime, leading these offense rings, that we hear about, who will be captured by this provision. The break and enter piece as well, the new reverse onus there, is going to capture a lot of people who, allegedly commit an offense that results in no physical harm or injury, who might be dealing with severe socioeconomic challenges, maybe they're dealing with substance use challenges, who are now going to face reverse onus provisions as well. And so these are two, that we've particularly said are overbroad, and that we really think just bear no connection to the types of issues that the government has stated it's trying to address, that we intend to suggest should be categorically struck. We're going to say that for all the provisions, but these ones, I think, will perhaps have the likeliest chance of some type of amendment activity. The other element as well is that there really are fundamental constitutional compliance issues with this bill. When the Supreme Court has considered reverse onus provisions, and they did so most substantively in two cases in the early 1990s called Pearson and Morales, they've set out some pretty clear criteria around when they can be justified. It has to be a narrow set of circumstances necessary to promote the proper functioning of the bail system cannot be undertaken for any purpose extraneous to the bail system and cannot be overbroad, cannot be any further than necessary to accomplish the objective. So I think you can already see how the case examples I referred to are in tension with those guiding principles. But in addition to that, even in the cases that were considered by the court in the early 1990s, which concerned various controlled substance trafficking and production provisions, the court said, well, we don't have the exact evidence before us on the bail-related issues with these provisions, but we can extrapolate from some observations that have been made and data that's available related to the United States. There was some effort, at least. Now, I would agree with the dissent, but there was some effort, at least, that okay, we have some type of information that justifies a different approach to bail in this circumstance. As I've noted, that information is not available for this bill. So there really hasn't even been an attempt to really do that work here. And the Department of Justice charter statement on this bill actually has a lot of very concerning observations. So one is that the reverse onus is justified because any person charged with the enumerated offenses is most likely to pose a risk to public safety. That's a fairly significant claim to say that we can say these are the groups of offenses that most likely pose a risk to public safety. But again, not supported by evidence, and I think belied by the fairly heterogeneous nature of these offenses and their potential factual circumstances. The other rationale the government has relied on is they've said that release in any case across all of the offense categories would undermine confidence in the administration of justice. It's a fairly sweeping proposition and also a fair, clear misreading of the understanding that we have in the jurisprudence about confidence in the administration of justice as a ground for denying bail. The Supreme Court only upheld that ground on the basis that a court has to conduct a really case-by-case analysis to ever deny bail on that basis, and that a reasonably informed member of the public, if somebody had no criminal record, was facing weak allegations, had a strong release plan, was ordered detained, would actually lose confidence in the administration of justice. So it's a very peculiar charter statement that doesn't really seem to connect to how the Supreme Court has outlined when a reverse onus can't be compliant with the charter. Lastly, I'll just briefly mention, and then I'll wrap up, is there's also one potentially positive thing that's coming out of all of this, and that is a new requirement for data collection. Well, that's putting it a bit too far. A reporting requirement from the Minister of Justice to report back on certain issues in the bail system, including rates of recidivism. And so, on the one hand, I think this is positive because there's really been hesitance to have the federal government step up and play a role here. On the other hand, there's a real risk it just becomes another kind of partisan exercise, right? If you have cherry picking of various stories and the government of the day just provides a report that fits its narrative. So we're proposing an amendment that I think is relatively modest in scope, but still helpful. It includes ensuring that report back includes information on rates of pretrial detention, a specific statutory role for Statistics Canada, and consultation requirements about what information should be in that report with civil society. So that, I hope, is a helpful snapshot of what is going on in Bill C-14. As I say, there are a lot of moving pieces, and I hope our brief will give you a more detailed review, but I think that captures some of our most pressing concerns with the bill. So I'll hand it over to Catherine, and thanks for listening.
Thanks very much, Shakir. I think that was most helpful. You've done a very thorough analysis of the provisions, and all of us are very grateful for that. I just want to raise a couple of points before I assume my colleague Rhea is looking to see if there are questions in the chat that we will pose to you. But in the meantime, just a couple of things that I would like to say. One is the theory behind these provisions, I absolutely agree with you, does not have an evidentiary base. And that is, from the basis of the witnesses that we've heard, there's a concern about car theft, there's a concern about retailers having their property destroyed and one thing or another. But there's absolutely no evidence to suggest that there's going to be a reduction in that activity by clamping down on bail. There's nothing to suggest that it is people on bail who are disproportionately committing those offenses, which I think is a real problem. I mean, your rationale for that it needs to be that. And if they're worried about crime in general, then the theory behind this bill seems to be if you clamp down, you got more people in pretrial detention, you're going to have less crime down the road. And that's absolutely not, that theory is not in any way sustained by the evidence, which is a real problem. The other thing, just to go to some of the things that Mary has indicated, my view is that those who have charter concerns or questions about the constitutionality of any bill need to appear as witnesses before parliamentary committees at this time. There's been a recent Supreme Court of Canada decision in Power, which indicates that if Parliament knowingly passes laws that violate the charter, they can be held liable for them. And we know by the number of laws that have been struck down, the number of mandatory minimums that the Supreme Court has struck down, my own personal concerns about the Structured Intervention Unit and Bill C-83, that the Department of Justice does not have a good record of forecasting whether something is charter compliant or not. And we need to get people who have expertise in charter compliance to appear before parliamentary committees and really raise these issues, which I don't think we're getting now. But I think as someone who has been a policy analyst and legislative reform person for decades, this process and this bill in particular is very disturbing in terms of its lack of rigor, in terms of process and content. So those are my 2 cents worth, but I really want to thank both of you for raising those concerns. Rhea, do we have any questions coming from the?
We do have one right at the moment, and I think it's a very interesting question. Might be difficult to answer, though. Could JHS or our panelists today offer a call to action for those of us that are attending? When facing a government in house who do not care for or are not interested in serious study and debate, how do those of us who do care proceed? I said it might be tough.
Well, I'm happy to take an initial attempt at that, and I think it is a very important question. And what I would say is that I would say a few things. Even when, and it is hard, and I'll say this as an advocate for myself, even when it feels like you're facing some terribly long odds, both in the realm of public opinion and before committee or in the legislative process, differences can be made. And they might be modest, but they still matter. And what I would say is that it still does make a difference for members of parliament and senators to hear from organizations and individuals who have these experiences. And so writing to these people, requesting opportunities to meet, particularly if there is anybody with lived experience who is willing to share it, I do still think plays a valuable function, because a lot of those with who have resources and power in our society and are well networked in terms of government relations and that kind of thing are being heard, and others are not. So I would first say that I do still think that kind of direct engagement can make a difference. And in particular, I would say that it can make a difference in the Senate, because I think we do have a less partisan environment and a more, more willingness to listen to experts in Senate committees. And so I would say don't lose hope in that sense, and that still make that effort. But second, I would also say, I do think trying to continue to get a different narrative out about the bail system can also make a difference. And so, for example, many of you might be familiar with the case of Umar Zamir, as an individual who had been charged with first-degree murder and the killing of a police officer here in Toronto, was released on bail. Decision was widely critiqued. Later, it was found that officers had essentially colluded. He was an innocent man, etc. And we as CCLA really emphasized that story and prior comments that had been made and all the rest of it, and it did get a lot of traction. People started talking about bail a bit differently. It resonated. And so, we might try that on 10 issues and it only punches through on one, but it does still punch through. And when we brought up that story in committee on the study of bail, even the conservative critic could not push back. He was like, "Oh, that is how the system should operate." So that was interesting, that you even had that kind of concession. So I think those would be two of my comments. And of course, lastly, I'll say this, is like certainly also where the government can behave in this manner, but they are not the final say on whether something complies with the Constitution. And so I think that litigation and supporting those efforts, whether through communications and messages of support, is important as well.
Yeah,
Mary?
I would just add to those excellent points that you have to keep at it repeatedly. I often heard when I was a public servant, well, we wrote a letter or we sent an email. Okay, that's great. But, you got to do it repeatedly, because I can assure you that the voices speaking against your opinion are doing it repeatedly. So it's not just a sort of one-time thing. Look for the voices that would be receptive to hearing you out and indeed would probably agree with you. And as I mentioned, in reading through these miles of transcripts, MP Fortin was very impressive. In the House, there's an NDP MP from Nunavut who spoke very eloquently, was very balanced. So it's not sort of a question of, well, what political party, but trying to reach the people that are natural allies and support them with facts that they can then use. It's, these issues, some of them are very difficult when you're put on the spot as a witness, believe me. In one of the meetings, every witness was asked, well, did you consult victims, in developing your proposals? Have you ever talked to a family of a murder victim? Have you ever, and it's that very pervasive, very obnoxious attitude that if you're with, an offender assisting agency or you're a public servant, that somehow you live on another planet and you yourself have never been a victim of anything. But it is very difficult in that moment. And Emily will remember one panel we were at the Justice Committee when the person who went first was, it was a devastating story. These are really terrible, terrible events that have happened. And the witness was, crying extensively. And I was the next witness to speak after her. Well, what do you do in that situation? It's so difficult. But you have to think through then. So how are you going to handle that? What is your response going to be? Case did a very good job in their testimony saying that, once again, it's not tough versus soft on crime. It's smart versus stupid, or smart versus, not effective. But to try to press that fundamental message, because there are political figures who are relentless about pushing a narrative of, we have to do everything we can for victims. And I certainly agree. We have to do everything we can for victims. We also have to do everything we can for the people in conflict with the law, who also have some tragic stories. So I think that sort of persistent messaging and looking at the content trying to avoid always having it set up as an us versus them, but rather as how do we collectively go about using the things that we know work. One of the police witnesses actually said in his testimony in response to a question, do we need more mandatory minimums? And he said, well, mandatory minimums haven't been shown to have any effect, there are people that are open to those arguments. And if you can get away from that adversarial approach with some difficulty, yes, the Senate, I would agree, the Senate has always been less partisan. The Legal and Constitutional Affairs Committee right now has a chair and a vice chair who have a particular perspective. That's their prerogative. So you have to be aware of that too when you're addressing them and trying to persuade people. But you got to be relentless, just relentless. Possibly
So
until you're 73 and think I can't be relentless anymore.
we do have one other question, and I'm hoping Catherine will, I don't know what happened, but that she'll pop back in a moment. Do you have any thoughts on the YCJA changes that also seem to have put in C-14 with no connection to their stated purpose for the bill? Does that make sense?
Oh, makes sense. Yes.
Okay.
I confess I haven't paid a lot of attention to them, having been more focused on bail and the sentencing provisions as well. But I think that those amendments on the YCJA are part and parcel of this approach of, we just have to get tougher with these kids and get their names out in the newspaper and, treat them like the full-blown criminals that they are, which of course is so antithetical. Catherine, of course, having been one of the main authors of the YCJA, she could tell you a lot more than I can about why that was done. And in the early days of the YCJA, and maybe it continues, youth incarceration plummeted. It was really gratifying to see, with no big increase in crime, of course.
Yeah, and I would note that so that act, the change I think that Mary alluded to regarding removing judicial oversight of publicizing the names of a young person who has been charged. It's one where we're trying to focus an amendment to still retain some degree of judicial oversight, such that the provision now is drafted so that if the police release the name and they don't do so for more than 24 hours. Justice will never review that decision. So it creates a really concerning gray zone. There's also another provision in there about the YCJA that would modify the circumstances and scope of record retention of young persons. Criminal Lawyers Association has a good amendment on that. So there are concerns with them. We are, and other organizations are going to be active on them. But there is also, I think, a really important warning sign there, because the police and others are talking a lot about the YCJA and trying to link it to crime in the same way they've done with bail without the evidence. Mary rightfully refers to the fact, and that data continues, that you saw a huge decline in incarceration, but not a corresponding increase in youth crime. So I think that's an area where we're going to have to be proactive, not only pushing back against some of these changes, but ensuring that deeper cuts or attempts to compromise the YCJA do not occur.
Well, unfortunately, I did get a message from Catherine that something happened to her computer and she won't be back, but I would like to, on her behalf, thank you both very much for coming. It was a very informative presentation. Certainly a lot of information that I think more people need to know. And we really appreciate your time. Thank you all to our participants for attending today, and we hope to see you tomorrow. In the meantime, happy John Howard Society Week. Thanks, everyone.
Thank you.
Thank
Bye-bye.
you.